Good evening, everyone. We'll begin with the webinar in the next 5 minutes.
Dear organizing committee members, am I audible?
Yes, you're audible.
Okay. So how my screen is showing? Actually, can you see the infinite windows?
Yes, sir.
Oh, okay.
Neither.
Hello, everyone. A very good evening to all. Can you just react if I'm audible enough? Everyone? Thank you so much. I hope you all are doing well. We are really happy to have you join us today for another exciting webinar hosted by the Legal Quorum. Today's topic is something that affects all of us, whether we are lawyers, students, or just regular users of the internet, and that is data protection. From how our personal data is used to the legal safeguards in place, there is so much we all need to know. Before we get started, let me quickly introduce the legal quorum for those who may be joining us for the first time. So, we are a law blog and legal platform that shares articles, case summaries, and legal career tips. We also post regular webinars like this one to bring valuable knowledge straight from experts to learners like you. Our goal is simple to make legal learning clear, practical, and accessible to everyone. Now, let me introduce a speaker for today, Mr. Vemuru Krishna. He's currently teaching as an assistant professor at Siddhartha Law College and is also pursuing his PhD in cyber law and information security at NLIU Bhopal, which many of you know is one of the top law schools in the country. He has presented papers at more than 10 national and international conferences and has published in leading law journals. His academic work, combined with his research, gives him a solid grip on the real world issues in data protection and cyber law. The topic for today is mastery, data protection laws, GDPR, DPDP Act, breach case studies, and future legal career opportunities. It's going to be a very helpful session. We'll touch on the basics, look at real cases, and also talk about career options in this field. With that, I'll now hand over the session to Mr. Leela Krishna. So, we're very excited to hear from you. The virtual stage is all yours.
Sir, your voice is not audible.
Can you please give me a minute? I'll just start within 2 minutes. Okay. Thank you for your patience.
Sure, sir.
Sorry for the delay. There was a technical glitch. Is my screen visible?
Yes, sir, it is visible.
Yeah. Thanks a lot. Thank you for your patience. Today we have joined to have a good and proper and exhilarating discussion about an emerging and a burning topic, which is important for all of us. And I'm glad that you are showing your enthusiasm to join for a webinar, that too in a weekend. Yeah, in a weekend. Because you see, we, a human being, and even the students and the employees, even the advocates, they would have the weekend mindset because we will work hard for continuously for 5 days. For us, Saturday and Sunday are considered as a days to relax. But even for this time, that in the evening, around 90 people have joined to this webinar. That's a good thing, and you need to cheer yourself first for this, and your enthusiasm to join for this webinar is considered as a mark of achievement first. There will be a key takeaways of your webinar, but your enthusiasm to join for this webinar is considered as a first and significant achievement. And by knowing about the key provisions of data protection laws, you will achieve numerous achievements. So with that spirit, I will start my the presentation and lecture on the mastering the data protection. I just wanna have a deliberation about this. It's not a one-way lecture, just like I will be providing a lecture and you will be listening to that. You can ask any kind of question regarding this particular subject, even in the middle of the session, and we can discuss about different aspects. So, with that, taking that in spirit, let us start with our presentation. So प्रेजेंटेशन का ऑप्शन किधर है बाबू? प्रेजेंट स्क्रीन का ऑप्शन रहता है, सब समझ में नहीं आते किधर है. Is my screen visible to everyone? Can you see the presentation?
Yes, sir.
Yes, sir.
Yes, sir.
Okay. So hello everyone. Hello, the term which I will use for you is hello the data enthusiasts, because you have enthusiasm about the data protection and about the finding certain career opportunities in the data protection laws. I know you are excited in learning about the relevant and landmark data protection laws like GDPR and DPDP Act. So first, before starting this lecture, I just want to ask a question to you. What interested you to join for this session? Is this about the curiosity about the privacy laws, or do you want a career growth in the legal tech, or you have a concern about big data breaches which are happening a lot, or you have any other option? You can you can provide your answer in your respective chat boxes, whereas you can provide any other option here. So let's take a moment and let us know what interests you a lot, and as per your interest, I will cater this session. Okay. So I'm willing to see your options which you will provide. Okay.
Good evening, sir. I am Kaustubh Rao,
Yes.
a law student of 3YDC. Now currently second year, second semester
Okay.
in local college.
Yes.
So
Which
I
college?
don't have correct guidance what to do after completion of my LLB. So I'm looking out for the opportunities, not only on litigation, others from litigation, corporate and other laws. So I'm just roaming to see what are other opportunities and how it will be useful to me. For that, I attended this session. How data protection law will become a good career opportunity to me.
That's great. That's great. And you will have key takeaways, and you can plan your career with this, because I will provide you with certain career opportunities. Whereas after completion of a course of 2 years, after your LLB or anything, uh, you land a job in big five companies. Even that is also possible. Okay. So certain people has written they are interested in data privacy laws, and there are certain people written they are interested in it as a career opportunity, and they want to pursue law. And certain people have written they have interest in data protection laws and knowing how we can protect our privacy. Yes, you are considered as a master of your data, and you can protect your privacy. And with this class, with this the short class of 1 hour, you will know about the relevant rights which you have and which you can enforce against the big companies like WhatsApp, Facebook, etc., and etc. So, okay, with this, what I can say is that the people are equally divided into two kinds. Oh, and each and every student is showing their interest in knowing about data protection laws, and along with knowing about data protection laws, they are interested in knowing about career opportunities. So both the knowledge and the utility of the data protection, people have the equal weightage. So I will cater your needs by discussing about both the things equally. Okay. So why do you think that the data protection is still relevant and it matters for us in the 21st century? that too in the digital age. Why do you think that the data protection is important? You can answer this by unmuting your call. Can anyone answer this? Why do you think that the data protection is relevant nowadays? Anyone can answer this question?
Sir,
Uh,
as we are too digital right now, that's why we need a proper protection. Uh, as I think so, that protection of personal information from any kind of unauthorized use, we need this Data Protection Act because previously we have only the IT Act and the SPDI rules of 2011. On the basis of that, there is no clear clarification or the rules given for the data protection of a personal identity or personal person. So we need this data protection to protect ourselves or our data.
To protect our own data. Right. That's a good thing. Can I know your name?
My name is Shreyas Rastogi, sir.
Okay. So can anyone answer? I think. So I'm giving a chance to another student.
Sir, the basic problem is that with the increasing use of AI, the data privacy is becoming more and more important because nowadays we can see that very easily our data can be accessed to anyone. We have like currently in 2023 a Data Privacy Protection Act was launched, but somehow I feel that it's quite vague and it's not that implemented in India right now. So basically, for like implementing it more better, it's very important first of all to know what is data protection, and second of all, how we can protect our data.
Okay. Okay. That's nice. Can I know about you? What's your name?
So my name is Nandini Agarwal.
Okay. So where are you studying?
Sir, I'm studying at Bharatiya Vidyapeeth Law University, New Delhi.
Okay. Nice. So you have answered it very well. That's good. And for your kind notice, even till now, the DPDP Act is not effectively implemented in India. So we will look into it later on. So okay. So as the students have answered, it's not like the data protection is the concern of certain elite individuals who have a property and they value their property. Data protection is a concern and it is an aspect of each and every individual who is residing in a country. Yes. Even if a person is not using their mobile phone, even if a person is not having any account in social networking site, even their personal information would be in huge peril because of lack of protection, lack of implementation of standards. Has anyone heard the term of shadow profiles? Shadow profile, dark profiles. Has anyone heard this particular term?
Yes, sir.
Yes. Can you answer?
So the shadow profiling refers to the collection of personal data. Like I am collecting a personal data of someone without their knowledge or consent.
Okay. Collecting the personal data without knowledge and consent. Can you give an example for that?
A person who has, I mean, he is not on social media, but the third person is making an account of him.
Yeah. In a way, you have given the right answer, but in a way, it's half right and half wrong answer. So basically, the shadow profiles is that it is a profiling tactic of the big business social media networking sites, just like Facebook and Instagram. So what they do is that even if you don't have any account in this particular social networking site, they will just create a dark account of you. How they will create? For suppose let us presume that I don't have any social media account, but my friends have a social media account, and I went to a particular restaurant along with them, and a friend has clicked a picture of me along with him, and he posted that picture in Facebook, and he tagged all the individuals. So he couldn't tag me because I don't have any account, but my image is stored in the Facebook. And later on, for suppose this same kind of thing happens again and again, if my images are stored in the Facebook cannot relate my image to my profile because I don't have any profile. So for that reason, to profile me, what Facebook would do is that Facebook would create a shadow profile on my name by giving a particular identity to me. He will just say this particular individual is X, and X is like this. X has a preference to go to a particular restaurant. So the Facebook will create a dark profile on my name. What happened later on is that when I create a social networking site account, just like when I create the Facebook, I could I could have all the photos which were clicked and posted by others about me. So how I could access my own photos in the Facebook when I don't even have any kind of Facebook account? Because it will recognize my identity through my photo, and it will relate to the photo which I will post after creating my account, and then it will relate both the images, and it will provide the images to me. So you see, even if I don't have any Facebook account, my data is being shared and being stored with Facebook. So I use this example in my classes and even in the discussions to say that the data protection is a concern of not the people who are not only the people who are using the devices, but for each and every individual. And there are certain other reasons which specify why the data protection is important. The first reason is ubiquitous digital presence, because here the data protection is considered as one of the significant aspects, and it is one of the personal security imperative, because certain data breaches like identity thefts, which are costs around $12.5 billion globally. Our data is this much of valuable and important, and even in the society as well, the data is considered as one of the important and essential aspect for the states as well, because the state is also trying to snoop our own data. The best example for this is Pegasus spyware case, which we will discuss it later on. So that's why the data protection is important. So by keeping this in our perspective, we will begin our journey about this particular webinar. Whereas first we will discuss the different provisions of GDPR and DPDP Act, and we will look about a different kind of breach case studies, and we won't even imagine what kind of breach which has happened and what kind of fines which are imposed by the relevant organizations, and you will unlock certain future career paths regarding the data protection. So this will be the framework of the lecture. So before going into the next slide, uh, if I say you will have certain rights which are important for data protection or as per your perspective, what kind of rights are important to you in the aspect of data protection? Can anyone answer what kind of rights regarding data protection are most important?
So I guess GDPR is
The
very
right to
important.
privacy.
I am just asking about rights, not about a statute. I'm asking about the general rights.
Right
uh,
to privacy.
right to
The
privacy.
right to privacy.
Right to privacy. right to privacy.
And sir, I
In
think
Article 21 of our Constitution, it's clearly said that right to privacy is our basic fundamental right, where even it applicable to digital privacy also, sir.
It include it
It includes
right to
digital
privacy
privacy.
means and includes info. They have used the term informational privacy. Yes, even the digital privacy as well. That's right. You're saying that right to privacy is important. What are the
I think
different aspects of right to privacy? How can you access your right to privacy? You said that right to privacy is important. Yes, right. It is. It is
Uh, we can
inherent.
access our right to privacy by accessing our own data,
Yes.
which we have shared, and we can manipulate our data, our own data. I mean, we can change our data or delete. We can manage our data. Could be a good thing, which is helps to maintain our right to privacy.
Yes. So you're saying that in a way, what I could understand from your answer, that you are saying that an individual should have a control over his data.
Yes, sir.
Okay. So can anyone contribute to this particular discussion?
So can I speak?
Yes, sure.
Sir, it is important that we know what sort of data we're sharing, but at the same time, it should not be restrictive. The data shared should be in an informed manner. In the sense, the other person, if it actually giving our data to a platform, then that platform should actually give us some guidelines or some rules based on which we can understand that this is the extent to which I can share data, not more than that. So
Not more
boundaries are
than
necessary,
that.
but it should not be restrictive.
Boundaries are necessary. It should not be restricted. That means the person who is collecting the data from you, you should inform about the different kind of aspects for which the data is being collected. Am I right?
Yes, sir, absolutely.
Yes. Okay. Can I'm giving a chance to another student as well. You can
So
contribute.
like, like we use WhatsApp and there's a term like end-to-end encryption.
End-to-end
So
encryption.
it
Yes.
protects the chats and privacy which we do, which are going between two person. So
Yeah.
it just gave a sort of privacy.
Okay. So you were saying about data security. Data must be secure. Whatever data which you shared with any of the social networking sites, the social networking sites has an obligation to secure your data. Am I correct?
Yeah, we should be ensured that any third
Yes.
party is not having access to our data.
Any third party is not having access. That's right. So the yes, yes. Can anyone answer? Anyone can answer. So I'm giving a chance to another student as well if they want. So okay. So the thing is that I have taken the remarks from three students, and three students has given three different answers about what kind of rights which are relevant, and the answers which you have given are considered as a foundational bedrock for the data protection laws, because the data protection law says that an individual should have complete control over his data. Why an individual should have complete control over his data? Because that data belongs to that particular individual. That's why whenever we are speaking about data protection, we are not speaking about non-personal data protection. We are just speaking about the personal data protection. What is meant by personal data here? Personal data means the data which belongs to one particular person is considered as a personal data. So if I am willing to share my data to another individual, what the law says that I should exert certain control over that particular data, and the answer which is given by the second student, it says about whenever I'm sharing my own personal data with others, I should be informed about what kind of data which is being shared by me, and for what time I will share this particular data, and how they will secure this particular data, and how long time they will use my own data. So whenever I'm sharing my own data, I should have certain informed consent. It is known as informed consent. And the third essential aspect is whatever data which I share with others, such kind of data should be secured. The the data collectors here, they should protect our data in a secured manner by following certain security practices. So these three aspects are considered as at bedrock of the data protection laws. Why we have data protection laws? Because inherently all over the world, the countries, the states has recognized right to privacy of an individual as a basic fundamental human right. In Europe, in USA, in India, in South Korea, in Australia, the constitutional courts, before even enacting the data protection laws, they have recognized that an individual should have certain right to privacy. One of the aspect of right to privacy is to have a control over his own personal information. The issue, the control of personal information is not new. It doesn't started with this mobile phones and even with these tech devices. It has started. It has started at a time when man has started the construction of his homes, because in ancient times there is a particular notion which is prevalent. It said that a man's home should be considered as his own castle. He should be considered, he should have utmost control over his own home. He should have control over the affairs which are happening in the home, and he shouldn't be interfered by while exercising this particular control. Right? There is a landmark case which has recognized this particular aspect even in India as well. That is considered as one of the basic cases for right to privacy. You might have heard about the Karak Singh's case, which says that the police domiciliary visits beyond the working hours during the night time is considered as unconstitutional. So at that particular time as well, the people have innate interest to protect themselves from gossip of others, because if you are gossiping about others, you will ridicule about a person. A right against the gossip was prevalent at that particular time. Just like that, the concept of this informational protection has emerged from there. Because you see, in the earlier times, there is a law to protect your letters, the information which is provided in the letter. In U.S. Telegraph Act, which enacted in way back in the 15th century, whereas there is a law which says that if if the letter is provided in the sealed cover, the middle persons, means the postman or the delivery man, they are not supposed to open that letter to read into the contents of the letter. It is considered as infringement of basic right of privacy. So that's how this kind of right of data protection has been emerged in significant phases. And now we say, whenever we are speak about this data protection, the law of European Union, that is GDPR, General Data Protection Regulation, is considered as a significant and a landmark legislation. Why? Because because of this implementation, you will see what kind of fines which the data protection authorities has imposed, and even our own data protection law, that is Digital Personal Data Protection Act, is hugely inspired from the GDPR. So The General Data Protection of Europe is considered as a foundational legislation upon the basis of data protection. It is enforced since May 15, 2018. It is a EU's cornerstone legislation of the data protection, which has around 11 chapters and 99 articles. It space about different aspects, out of which uh, the major aspect is the rights of data subjects. So, before moving forward, we need to know one thing. The data subject means a person whose data is being collected by others. For suppose, if my data is collected by WhatsApp, I will be considered as a data subject. Okay, certain rights are provided for data subjects, and who is collecting that particular data, he is known as data controllers, because the data controllers will collect the data, and the data processors are considered as a middleman, because they will process that data for the specified purpose of data controllers. You need to know and you need to notice there will be three different stakeholders in data protection laws. One is a data subject, data controller, and a data processor. I am a data subject. Data controller is the one who collects the data. For suppose Facebook is the data controller, and who will be the data processor? For suppose if you are using any of the intermediary services, the intermediary services which would become the data processor. So this particular GDPR has recognized different stakeholders and has recognized certain rights for the data subjects. This GDPR is applies, it has its territorial application to the whole of European Union region, and it impacts around 500 million people. And you'd be surprised if I say that it can fine which can exceed 4 billion by 4 billion. That's the amount of fine which it can impose. And in one particular landmark aspect about significant data breach, we will study about this particular thing. So, as I have already mentioned, it has provided certain basic data subject rights. The rights which a person who is sharing his own personal information can exercise. One of the basic rights is the right to be informed. Yes, one of the student has specified about this. The basic right is the right to be informed about how the data will be collected, and in what ways it will be collected. So this kind of right to be informed is exercised by the data subjects in the manner of privacy policies. In the privacy policy, they will provide a mechanism or a manner upon which our own data process of collecting our own data. Has anyone read the privacy policy? Anyone can answer this question? Have you ever read the privacy policy? So most of the students are silent, and I know the reason for this, because the major problem with the privacy policies is that they are lengthy. So your journey with this digital devices will start with the privacy policies only. For suppose if you buy a new phone, uh, you can only use that particular mobile phone only after giving consent to that particular the brand of mobile phone, that they could process your personal data, and they will provide how they will process your personal data, and they will provide for what purposes they will process your personal data. It is known as privacy policy. You cannot access any kind of device without accepting the privacy policy. So you cannot access this Google Meet, which we are using, without accepting to the privacy policy of the Google Meet. And there is another significant future of certain aspect of a privacy policy, which is applicable for the future actions as well. Has anyone read or has anyone know about the concept of cookies? I'm not asking about the cookies which we eat, about the cookies which are there in the websites. Do anyone know about the term cookies?
Yes, sir.
Yes. Can you please answer about this? What are cookies?
So actually, they trace our data. It means whenever we visit a particular website, they trace our data and it keeps a record. That's
Yes. It keeps a record. It doesn't only keep the record of your past transactions or past browsing history, but also your the future browsing history as well. What it will do is that whenever you accept cookies of a one particular site, it will track your preferences. For suppose if I accept the cookies of Amazon e-commerce platform, what it will do is that it will just track my preferences of my web information. For suppose afterwards, if I search something about a mobile smartphone or anything in Google Chrome, by implanting those cookies in my web page, that is Google Chrome, it could track my search history and it will track my preference and it will store that data. With that, what it could do is that when I access this Amazon Prime account again, it will show the feed as per my own preference, which I searched in Google Chrome. With that, what they claim is that they are providing the personalized service, but it's not beneficial for us, but it is beneficial for the big business entities. So it is no. So one of the basic and cardinal right which the individuals exercise is right to be informed, and the second right is right to access, because it says that the right to access says that you need to have an access of your own personal data. Because of the GDPR's implementation, this right is exercised over all the social networking sites. For suppose, even you can access your WhatsApp history by requesting for the data from the WhatsApp. If you go to the privacy settings of the WhatsApp, it will provide this significant feature, whereas the WhatsApp will provide all the conversation history to you. Why the particular option is there to you? Because it is it can be enforced as a right, because it is considered as a significant right under the right to access. Not only about right to access, there is another right which is there, that is right to eraser. Right to erase is draws from the cardinal aspect of right to be forgotten. This right is, that's why a opportunity or option is given to the individuals to erase their own data. So it is exercised in the different social networking sites as well. The significant example for right to erase is that you can delete your old posts or old feeds in the social networking sites. For suppose if you see, we are all human beings, and we are all considered as childish human beings, childish and foolish, because for one particular time we would have an interest to share or to provide information about different things, and after some time what we could realize is that whatever we have shared earlier, certain kind of information which will might affect our own reputation. That's why we 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 will think to delete that particular information, erase that particular information. I will truly say that it might have happened with each and every individual who is attending this particular webinar. Not only this particular webinar, who is using this particular social networking sites. Because you see, for certain things, I have a lot of friends who will share about certain the breakup posts, if they have encountered with a breakup posts in WhatsApp, in Instagram, in different social networking sites. But later on, when they think that if the post will remain in their own social networking sites, it might affect their future relationship prospects. What they would do is they will just delete that particular post. So I'm giving this example. It might happen in different kind of in different kind of aspects. And recently, you see, even Donald Trump as well. He has even given a mandate to the mandate in USA that to consider for the visa of a student, he will scrutinize the social networking sites, and he will scrutinize all the posts which are prevalent in social networking sites. So, what option which the students who are willing to establish their careers in US have now? They need to delete the earlier post before going for visa process. So it is known as right to eraser, and there are other significant rights. One of the significant right is right to restrict processing. If you are not willing to process certain aspects, you would be provided with the right to restrict that processing. For suppose this right to restrict processing is evident in the GDPR. What are the example which I shared about the cookies? The cookie processing is not there, and it is not considered as a mandate in European countries where GDPR is considered as significant law. You see, if you are searching for any of the European website, they will provide option for you to completely restrict the cookies, but it is not there in India because GDPR is not there in India. In India, there is not enough robust data protection act. In India, we cannot access a website without accepting for cookies. Okay. So along with that, there is a right which is there, which is known as data portability, because the data which is there for us, it should be transferred in a structured format. That means CSV file or anything. It should be transferred to different devices as well. So these are the different kind of rights which are recognized by the GDPR. I will provide certain examples. For suppose, let us say in Paris, Sophie requests for the purchase history from a retailer. The store has delivers it within 30 days. 30 days is the mandate time. It needs to deliver that. If it is not, if they couldn't deliver that particular purchase history, they would be imposed with a fine. Imposed with a fine. Okay, so just like that, in London, you see John asked for social media app to delete 2020 posts because he might have certain issue with those posts. So the app need to comply with that. Not only delete the certain posts, right to delete your social networking account is considered as a significant right. Usually earlier, before 2018, an individual cannot delete their own social networking site, including Facebook as well. But later on, because of the implementation of GDPR, the Facebook has complied with the provisions, and after 2018 only, we have got an option to delete our own account. Practically, it won't be deleted. But the thing is that nobody could access their own Facebook account. It is known as the right to deletion. So just like this, by conferring the rights to data principles or data subjects, the enactment has conferred certain obligations for controllers and processors. They have core duties. One of the major duties is that they should implement the data protection by design. Means their design of application or even in any infrastructure, such infrastructure should comply with the mandate of data protection. The best example for data protection by design is, can anyone answer this question? What is the best example for data protection by design? Someone has already answered this, but I am giving this option again. Can anyone answer this question? What is an example of data protection by design? Can anyone answer this question? Okay. So earlier a student has said that end-to-end encryption while mentioning about data security. So the mandate of end-to-end encryption is considered as a data protection by design aspect, whereas it integrates the privacy into systems. Along with that, they need to have implement certain other data protection standards as well, which includes anonymization, regular security testing by complying with the information security practices, and so on and so forth. And another particular significant obligation which the individual has is that whenever they have encountered with a data breach, they need to report that data breach within the period of 24 hours. So these are all considered as obligations which an individual have. If you look about certain other advanced obligations of the data controller, he has an obligation of collecting the data for lawful, transparent, and fair manners. It is the lawful, transparent, and fair manner for collection of data is considered as a bedrock for the collection of data. You see, the legal basis for collection in any country is consent. The data processor can only collect the personal data only to the consent of the particular individual. And that consent should be freely given, and it should be specific and informed consent. Informed consent means they could only collect the data through the privacy policies by providing an option for agreeing or disagreeing with the privacy policies. It is not like they are presumed that an individual has accepted to privacy policies and they can process the data. Before collection of data, it is a mandate to seek the personal data through the privacy policies. Okay. Along with that, they have mentioned that the data process and data controllers should undergo significant data protection impact assessments to to assess about the impact which will cause due to the data breach. It will be helpful for the significant data processors to assess and to have a secured process of protection of personal data. So this is considered as certain aspects of the GDPR. If we dive back to Digital Personal Data Protection Act, which is there in India, can anyone say what landmark case has led to the enactment of Data Protection Act in India? Which
Shreya
landmark?
Singhal case.
Shreya Singhal. Okay. Next. It's not that.
Certain case, Putaswamy versus Union of India.
Yes, it is chaos Putaswamy case. But you see, I can't deny with the answer which is given by with the person that is Shreya Singhal. It speaks about it's about the control of the data. But if I wanna have an appropriate answer, the answer would be K.S. Puttaswamy versus Union of India. Why this particular case is relevant? Because this case is considered as a foundational case in India, which has recognized right to privacy as a fundamental right. Even before that as well, in India, the aspect of information is regulated through Information Technology Act. But this Information and Technology Act didn't even specify or recognize or protected any of the aspects upon the protection of personal data. So to bridge the gap and to bridge the gap, the India has enacted reasonable security practices and procedure rules in the year 2011. And there is a significant loophole in this rules as well, 2011 rules. Can anyone answer that? What is the significant loophole which is there in 2011 rules? Two 2011 rules are not applicable to certain entities. What are those entities? Can anyone answer this question?
So I think data transfer to the
To the
abroad,
abroad.
data transfers.
Okay. So I'm giving opportunity to another student as well.
The data transferred or given to the government for some investigational purposes.
Yes. Yeah, you are given the right answer. Not only for investigation purposes, for the data which is transferred to the government in general. The 2011 rules are only applicable to the body corporates, which will collect what kind of data from individual?
Sensitive personal information data.
Yes, it will collect sensitive personal information. What is considered as sensitive personal information as per the rules 2011?
Uh, maybe maybe gender, age, like that.
Yes.
About our details,
Yes.
anything. If
Gender, age,
sometimes we can say male and female gender specification will be not that sensitive, but LGBTQ like
orientation.
that genders may be
It can be considered
more
as sexual
sensitive.
orientation. Yes. Sexual orientation, financial details.
Financial data.
Yes.
Genetic data, health
Genetic
records.
data, etc. and etc. The major problem is that the act didn't cover about the personal data, but only specified about sensitive personal data. And the other thing is that this act is not applicable for government. You see, I will tell you this thing. I even know the session is being recorded and even it will be live on YouTube as well. Even then as well, I'm not afraid to say this. The big abuser of personal data of an individual is government only. I'm not saying about any of the specific government in India or in abroad. Around worldwide, the abuser of personal data of individual is government only. And you will know about why I have said this thing later on. Okay, but uh, keep in mind about this thing. The big abuser of your personal data is not the body corporate. It is the government in general. I am not specifying about any of the government which is ruling this country or any of the state. I'm specifying about this in general, which is applicable, which is universally applicable to all the governments. Okay. So this 2011 rules, they are not enforceable against the government. So a debate of right to privacy has happened from the constitutional debate itself. Whereas in constitutional debates, they have came into a conclusion that right to privacy shouldn't be recognized as a fundamental right in India. But later on, significant deliberations has happened in the Supreme Court. But in the case of 2017, that is Justice K.S. Puttaswamy versus Union of India, the Supreme Court has conferred the status of right to privacy as a fundamental right, and it has provided that this right to privacy is applicable for both state and non-state actors. Fundamental rights are applicable for both state and non-state actors. With this, I will ask another question. Uh, Against whom fundamental rights are applicable?
Against government,
Against
state, state.
yes, sir. Yeah, thank you. Against state. Because Article 12 specifies about state, like, Article 13 specifies about law. And the fundamental rights are enforceable against the state only. But this judgment has recognized that the right to privacy is enforceable against both state and non-state actors. By recognizing like this, it has came into the conclusion that the mere recognition of right to privacy as fundamental right is not enough for protection of individuals. It has mandated for the enactment of data protection law in India. That's why we have the Data Protection Act in the year 2023, and we are living in 2025. Even till now it is not implemented, but we have got our Data Protection Act. But the inspiration for the Data Protection Act is this case Puttaswamy judgment. So you know about this timeline. The Personal Data Protection Bill 2018 is drafted first, and later on it was presented before the committee, whereas it was not. It was withdrawn again, and it was drafted in 2022 and the year 2023. In the year 2023, Digital Personal Data Protection Act has been formally passed by both the houses on August 3rd, 2023. And nowadays, to implement the act, it should happen only through the rules. That's the reason why on January 3rd, 2025, the Minister of Information Technology, which is considered as a concerned ministry to draft this laws on data protection, has published the rules for public consultation, and even till yet as well, we don't have any news about this particular thing, whether the rules are enforced or not. We don't have any news, but the timeline for public consultation has been passed, and they are in the process to review the feedback. Okay, so I have already mentioned we have inspired a lot from EU's GDPR, because a DPDP Act, just like GDPR, has considered right to privacy of an individual as a basic human right. Both the frameworks empower the individuals to have rights about the data access, data rectification. It imposes significant obligations on data fiduciaries. Data fiduciaries and data process, the terms are similar. The data fiduciary is the one who will collect the data. Okay, so don't be confused about these terms. Even the GDPR as well, it it imposes the penalty, and it caps the penalty of 250 crores, just like the GDPR's robust penalty mechanism as well. So that's what we have inspired. But even without this, we have certain significant departations as well. You see, in the Digital Personal Data Protection Act, as the Act only specifies, it is only applicable to what kind of data? Digital Personal Data Protection Act is applicable to what kind of personal data? Can anyone answer? So I'm repeating my question.
Digital personal data.
Yes, the Digital Personal Data Protection Act is applicable to only the aspect of data which is considered
Sensitive and personal data.
digital personal data. The act's name is only like that. It says about digital personal data. What is meant by digital personal data? Can anyone answer this question?
It's a sensitive and personal data of an individual.
Yes, personal data of an individual which is stored in a digitalized form. Digitalized form is known as digital personal data. For suppose if I store your names in a book, in a notebook with my pen, whether the personal information of you is protected under Digital Personal Data Protection Act?
No, sir.
No,
No,
sir.
sir.
If it is
Not?
stored in a
No, no,
drive,
no.
then it will be.
Yes. But someone has given a beautiful answer. For suppose If it is digitalized later on, then it could be protected. But if it's not digitalized later on, then this particular information which is stored in the notebook, it cannot be protected through this particular enactment. So it has confined its scope to it. And the later aspect is that in India, we don't have a significant protection against cross-border data transfers. Means the data which is transferred to different countries. But for suppose GDPR as follows: cross-border data transfers. So and later on we will see there are significant deportations as well. So, if you look at the jurisdiction of Digital Personal Data Protection Act, it is only applicable to the data which is in a digitalized form. Means data is collected through online or it is converted from offline to online. Each and every enactment has extended its territorial ambit as well. For suppose if the personal data of an Indian, if it is collected by Facebook, which is situated in America, even for that particular personal data as well, Digital Personal Data Protection Act is applicable because the data relates to this particular individual. Okay, and even before that, they have provided that the enactment is not applicable to publicly available data, or if a data is made public by an individual. If a data is made public by an individual, for that particular data, Data Protection Act is not applicable. Can anyone say an example for this particular aspect? In what forms an individual will make his data public?
Social media platforms
Yes.
like YouTube. We use YouTube to post videos, and
Yes.
public accounts in Facebook, Instagram, other apps.
Yes.
And private data will be Swiggy, Zomato. We give our address, about our name, maybe our age, our gender, like that.
Yes. Okay. So yes, you have given the right answer. The thing is that if I suppose if I post my image in the Facebook, I'm making my own image publicly accessible. For that particular image, the provisions of DPDP Act are not applicable. I don't know. They have just for with that particular omission, they have diluted the scope of the Digital Personal Data Protection Act. And the another exclusion is that if a person is uses that particular data for domestic purposes, domestic data processing, even for that as well, the enactment is not applicable. Here, the domestic purpose means the purposes which are not commercial. For suppose if you are not using the personal data for getting any kind of basic resource or revenue, then as well the DPDP Act is not applicable. So with this applicability provision only, what I can say is that the lawmakers have significantly diluted the application scope and ambit of Digital Personal Data Protection Act. It's like even if you have Personal Data Protection Act, it's not like it won't be enforceable and applicable for most of the cases. So, with this particular aspect, we will move towards the rights. Just like GDPR, here as well, the data principles are empowered with a different kind of rights. The right to access, the right to information, right to correction, and there is another significant right which is there in India, which is not there in GDPR. So it needs a huge applause because one of the particular right which Indian data principles have, Indian individuals have is right to nominate. Right to nominate. This kind of right is not evident in GDPR. What is meant by right to nominate? Can anyone answer? Right to nominate.
So, like we choose a nominee in our bank account, as
Okay.
same
Why
we
did we choose a nominee in our bank account?
who can access on our behalf when we are not present and we are not capable.
Yes. So that kind of right to nominate is there for crossing of personal data as well. You see, this right to nominate is important because after 50 years or so, what what Facebook has concluded that it has done a research, and the Facebook has concluded that there will be more dead accounts than that of active accounts. I'm asking about dead accounts. What is meant by dead account?
Inactive, which are not in use. Maybe
Inactive. Why
persons
they became inactive?
inactive.
Why they became inactive?
People may not interested to use, or maybe they died. Anything.
Yeah.
And
And they concentrated on the second aspect. If the person has died, who will have the control over the particular account? So Facebook doesn't have any answer for this. You see, a significant issue happened in America, I think, before 4 years. Basically, the issue is that before dying, a particular a girl, he posted her suicide video. He live streamed the suicide video in Facebook, and she died. And their parents couldn't access those Facebook account because they don't know the credentials. And the video of suicide, it became viral in the Facebook. The parents wanted to delete that particular video because it will affect their own, if have their own reputation. It unnecessarily people were speaking about that particular incident because that became viral. So they approached the parents approached the Facebook and requested the Facebook to delete the particular video. For which, for their response, what do you think that Facebook has responded for their request?
maybe deleted.
Yeah, if it has deleted, then there is no need for me to use that as an example. What happened was that Facebook has denied to delete that particular video. The reason which they have specified is that you see the account holder has willfully posted that video. Later she died, and only the account holder could exercise control over the account, and their parents, they don't have any access to this. By providing this reason, they deny to delete that video. So, so to rectify this kind of aspects, the Indian lawmakers have did a beautiful thing by recognizing this right as right to nomination, whereas it has provided an option to each and every individual to appoint a nominee, so that such nominee could exercise the rights in the cases of incapacity or after the death. For suppose if there is a right to nominate which is there for that particular daughter, if they not have if she had nominated their parents, the parents could have access that particular account and they could delete that particular video. But such right is not there in USA. That's why that incident has happened. So just like that, we have a different kinds of rights in India. Okay, just like you see, there is a significant aspect for Indian data protection law is that not only about rights, the law has recognized obligations as well. Obligation which a data principal need to follow. This kind of aspect, this kind of basic aspect is not there in GDPR. Certain obligations which are there for data principals is you need to provide accurate information. Whenever you're creating a Facebook account, you need to provide accurate information. You're not supposed to, if you're a male person, you're not supposed to open an account by just changing your gender. See, practice be used by your friends. Even you see, during health, when we have a true caller or any other service that uh, we used to tease our friends by opening the accounts with providing certain false information. So the Data Protection Act says that whenever you are providing your own personal information, you should provide an accurate information. So if you are not providing accurate information, it is considered as a wrong, for which penalty is also imposed. Do you know what is the quantum of penalty which is imposed against this? Can you answer? Can you guess at least? For suppose you have provided willfully incorrect information, what kind of penalty is there? Anyone can answer this question?
Actually, I'm first time it is listening. There is a penalty for giving inaccurate information in online.
Yeah, the DPDP Act mandates about this because of this kind of incidents only, DPDP Act has specified about this particular aspect. The penalty which they have given is, guess the amount of penalty at least. It is quite for anyone. You need to just guess the amount.
Maybe around 1,000 to 10,000 between.
Yeah, it is 10,000 rupees. 10,000 rupees fine. Okay. They are the purpose of DPD that they won't be implemented, but it is considered as cheating. The provisions of penal are applicable here. But if you are providing your manipulating your personal information, you will be penalized with fine of 10,000 rupees. And later on, the DPDP Act has started another duty is you are not supposed to file frivolous complaint against the data process and data controllers. If you file a frivolous complaint, it will unreasonably create hardships to others, right? That's why it says that you are not supposed to file a frivolous complaint. Okay? Just like that, just like GDPR amendment, it has provided significant obligations for data security. Because you see, the obligations are somewhat similar to GDPR. It specifies about consent, which is mandated through privacy policies, that there should be a minimal purpose limitation. They should follow reasonable security safeguards, and they will provide with breach notification. Means individuals will be informed if the personal data is unreasonable access by other, etc., etc. All these are similar to that of DPDP Act. Okay. Apart from this, in India, we have another aspect known as protection of children's data. Suppose children is considered as a person who is 18 years. The DPDP Act says that if children is accessing any kind of social networking sites, if he is sharing any kind of personal data, it should happen only through parental controls, only through parental consent. Because of this implementation of Act only, you see in India, a process is going on with all these social networking sites, just like Instagram, Facebook, etc., etc. So that whenever the children is using the social networking sites, the complete information will be repeated to the parents. Because you see, in the world there is a particular notion is there. If you are the age of 18 years, you are not a person who will decide on your behalf, and you are under supervision of your parents. That's why this particular aspect is there. You see, in a way, it is proper and appropriate because children could easily manipulate it, and certain issues might even happen because of such kind of manipulation. And if you wanna know about this, I will just I could take an example of GDNetla incident. I will request the fellow students to read about the particular incident. I won't deliberate about it. Okay. So next, they have provide about the consent mechanisms, so forth. And the under debatable aspect is that these provisions specify for significant exemptions. With these particular exemptions, the government can collect process the data without the consent of the individuals as well, on the purpose of public policy, safety, national security, public welfare, etc. And the government has done without the enactment of GDPR Act as well. One of the significant examples for this is that all with your own data, with your own personal data, which is collected by through the COVID-19 vaccine, whereas you have shared your data in portal to access vaccine, right? It happened online. So, what is the name of this website or an app? Whereas we have shared
COVID.
yes, COVID app. So COVID app, so that we could have access. The government has used the details of the COVID app, and without our consent itself, they have created an account of us in the name of health IDs. They have provided health cards. Without your consent only, your data is collected and shared to the different platform in the name of
But
our
sir, here right now privacy is there, no, sir. How can government can violate our
the problem is that
fundamental right?
if you look at section 14, it has given certain exceptions, and government is exempted from the application of the Data Protection Act. One of the exceptions is that it could collect and access the data for the purposes of investigation, prevention of crime, public welfare, public safety, public health, etc., etc. And they have used the ground of public health. I might have answered your question. Specific. That's why I have mentioned with you earlier about who is considered as a big abuser of data protection, personal data. Okay, so just like GDPR as well, the Data Protection Act has provided certain enforcement minorities. So this is about the Data Protection Act. So we have already discussed about comparison, whereas I have mentioned about inefficiency in Data Protection Act. We have restricted our scope. There is the absence of true data framework. Sensitive personal data is not recognized in DPDP Act, and we have certain underwhelming penalty because we see 250 crores cap is provided in India, but that's not there for GDPR, whereas the billions of dollars of fine and these are considered as inefficiencies. Okay, so afterwards, I just want to discuss about certain significant data breaches. So I will just end this in 10 minutes by discussing uh, about the career opportunities now. Before that, we will mention about certain significant data breaches. So one thing is that one of the famous significant data breaches happened in 2025, whereas the Meta has violated the provisions of the GDPR. Because of this violation, it was imposed with a fine recently. Fine is equivalent to 1% of global turnover of Meta. The fine is around $100 billion. That's the fine which is imposed. It happened recently only, and just like there are significant data breaches happen a lot with TikTok, Amazon, and even in India, there is a case of WhatsApp privacy policy. Whereas even then an issue happened with WhatsApp privacy policy, whereas the Committee of India has imposed 2.1 billion rupees penalty on WhatsApp because they are not following the proper consent mechanism. They are just collecting the data without our consent, and they are using the data for Instagram and providing news feeds for Instagram and Facebook. Just like that, there are other aspects. Now we will get into the important and essential aspect for our discussion. That is the second thing. That is employment opportunities which are there for data protection. See, data protection is known as emerging field because each and every country has a data protection act, and there are different kind of roles which are there due to the enactment of data protection act. The roles include data protection officer, compliance officers, privacy consultant, so on and so forth. So to have this employment opportunities, we need to have certain skills. Individual, primarily a law student, should have a legal expertise. The individual has the proper knowledge on the data protection laws, and he should be well versed with drafting of contracts, because a significant opportunity which will be there for you is drafting of privacy policies and analyzing privacy policies. That is the first entry level aspect for which you will enter in the field of data protection. And later on, if you need to have certain technical proficiency, you can also have, because you need to have certain skills of cyber security, and you need to have certain communication. So how will you get these skills? How will you acquire these skills? Do you think that any of the universities in India is offering in any kind of courses on data protection? Do you think that there are any kind of certification courses which are helpful to you to get these particular skills? What is the journey which you need to take up for this? So, key career opportunities which an individual have is data protection officer. It is considered as hierarchy. It is considered as a top level aspect. Data protection officer, he could earn for around 10 to 25 lakhs annually. Well, rather than that, there are certain other roles as well: privacy manager, privacy analyst, compliance manager, and so on and so forth. So how do you think that you could get this skill and how you could land to these kind of jobs? So one of the basic aspect is that because in this you can take a screenshot of this, because it will from this, because it will provide certain valuable information. The significant certification course which is available is provided by the International Association of Privacy Professionals. The certification, around 50,000 persons worldwide have certified with this. It has certain certifications across different jurisdictions, including GDPR, Digital Personal Data Protection Act, and even in India as well, CIPPA, Asia is applicable in India. So it costs around 40,000 rupees to get this certificate. But to get this certificate, you need to prepare properly. And there are another certification courses as well, which will be provided by certified data protection officers and uh, and COMT IA Security Plus. Once you get essential proper skills, you could get the certificate. But how could you get this appropriate skills for the data protection? So there are certain online certification courses which are helpful for you. For suppose Google Cyber Security Professional course, which is provided in Coursera, it could provide certain basic skills for you to have and proper understanding about the data protection. You see, the beautiful future of Coursera is that you can access this course for for the for the for the cost of 1,200 to 1,300 rupees per month, and it usually take around 6 months to complete this course. Just like that, there are other online courses which are there here. Cybersecurity fundamental course of edX is also important. It is also considered as a famous course upon this. And even there are different courses on data protection as well. For suppose a course is there which I haven't mentioned here, EIT Digital's course on data protection specialization, which is there in Coursera. That specialization consists of different kinds of courses, and this course is specifically co-funded by the European Union. So the course is important. And for suppose in Coursera, what I would suggest you is that you could get a scholarship from Coursera. To get a scholarship, you just need to do one thing only. If you write a letter, if you mail the letter to the Coursera, they will provide scholarship to you, whereas you can access the entire professional course freely. I did that. I have completed a specialization course from EIT Digital when I was pursuing my LLB itself. That course basically I did that by mailing to them for requesting for scholarship aid, and they are gracious to provide scholarship aid to each and every student. If you are if you need to provide your interest to learn that particular course. So even they have provided certain mechanism to gain that scholarship or that financial aid. If you could access any kind of course in that particular course, near the amount which is specified as enrollment, they will provide another option, that is apply for financial aid. After clicking at the apply for financial aid option, they will provide how you could get the financial aid. So it is applicable, and you can get a financial aid. And I am the example for this because I completed the course through the financial aid itself. Apart from that, because of the growing emerging need, there are certain institutions in our country as offering certain specializations on data protection. Out of which, the first thing which I specified, you can note it down. The course of Masters in Cyber and Information Security. It is offered by National Institute University Bhopal, Madhya Pradesh. Whereas after the completion of this course, you this course is providing the campus. This institution is providing campus placements, and you could you could get a job in this particular campus placements. And for this particular institution, the percentage of students who would be placed is around 60 to 70, and that is the statistics of the previous academic year. But even before that, it used to be 100, nearly 200. You can ask, why do I know all these things about NLI Bhopal? Because the reason being, I am in the process of completing my PhD from National Institute University Bhopal, and my domain of research is data protection and the data privacy as well. I have witnessed this particular thing. You will be surprised if I say certain students of masters, that is LLM, they have completed their 1 year LLM course, and they have joined again in this particular college in the course of MCILS, that is Masters of Science in Cyber Law and Information Security. And they have completed that course, and they have landed a job with a reasonable and decent package. That is
Sir, is it equivalent to LLM, that MCLS?
Yes, I'm going to answer that question as well later on. Yes, they get a land a job of around 10 lakh package per annum. That is the initial pay. Could you realize you could get that particular field or particular job if you pursue LLM? Because you don't, if you have a belief that if you pursue LLM in big national universities, you would have campus placements. Sorry to say this, LLM doesn't offer, even in reputed national universities, they don't have campus placements for the students of LLM. Okay, so that's the thing. So this course is beneficial and helpful because of the example itself which I specified. And for the next this thing, someone has said something. Can you ask that question again?
Sir, I was asking at that course MCLIS, is it equivalent to LM?
No, it's not equivalent to LLM. I'm about to say that thing after saying all this. It is not Master of Law. It is Masters of Science in Cyber and Information Security. Don't get confused with these things. It is not masters of law, LLM. It is masters in cyber law and information security. It cannot be equated as LLM, and you cannot pursue PhD in law later on after completion of LLM. It is not considered as LLM as per BCI norms. So, the career session which I will give it to you, apart from this thing, is that don't get confused or fooled with these institutions. I'm not saying about this particular course, because this course is providing a good placements and good employment to individuals. I'm saying about certain courses in general. For suppose recently, NLU Delhi has offered a course in the name of LLM Professional.
Yes, sir. It also offers contact learning as well as distance education is there.
Yeah, contact learning and distance learning. But if you read the notice carefully, in the minute basic lines, they have written that this LLM professional is cannot be equated as LLM as per BCI standards. What I am asking is that if it cannot be equated as LLM from as per BCI standards, why are you naming it as LLM professional? They are just trying to deceive the people, and even it is a tactic which is being followed by reputed universities like NLU Delhi as well. Here, I am saying this again. This is not LLM. It is Masters of Cyber Law and Information Security, MSc, Master of Science in Cyber Law and Information Security. But it is providing a good employment and career opportunity to you. For suppose there are certain institutes which are providing LLM in data protection. For suppose, I think in NLU Raipur, they are providing LLM in data protection, but they are not even offering any kind of placements. So that's why I have taken it as an example. Apart from that, there will be different post-graduation diploma courses of cyber law and cyber forensics. But you see, it is if you do all these kind of courses, it will be your own personal journey to achieve the heights. But for the course of Masters in Cyber Law and Information Security, for that the eligibility is graduate. It means even the student of BTech and even the student of law, they can pursue for this course, and later on, they could land in good jobs of big fat. So these are about career opportunities, and this is the about the basic aspects of the Data Protection Act and GDPR. If you have any points to ponder upon, or if you have any doubts, you can ask now.
Sir, the MCLIS course that you mentioned in
Yes.
NLIO Bhopal, it
Yes.
offers admission through CLAT PG.
No. Yeah, sorry. I couldn't. I couldn't say all the things. It won't offer the admission to CLAT PG. There is another examination, which is known as MCLS entrance exam, which is conducted by that particular institute only, NLIO Bhopal. If and you will get the admission notification at around the month of March, and the deadline would be in May, and the exam would happen in the month of May. It won't be under CLAT PG. There will be a separate exam, but you need to know another thing. The competition for this exam is less, because a lot of people don't know about this particular course. Okay. So anybody else? So with this, I'm ending my session. Thank you, everyone. Thank you for your rapt attention.
Thank you, sir.
Thank you, thank you so
Thank
much,
you,
sir.
sir.
Thank you so
That
much, sir.
was
Thank you.
Thank you so much, sir.
Thank you so much, sir. That was such a well-rounded and insightful session. You really broke down a complex subject in a way that was easy to understand, and your real-life case studies made the concepts much more relatable. I'm sure everyone here learned something valuable today, whether it was about GDPR, India's new DPDP Act, or the kind of legal careers available in data protection. Once again, thank you so much, sir.
Thanks a lot. Thank you for giving this opportunity.
And with that, we come to the end of today's webinar. A big thank you once again to Mr. Leela Krishna for joining us and sharing such useful insights. We truly appreciate your time and expertise, and we're looking forward to collaborating with you again in the future. So, before everybody leaves, all participants will get e-certificates. This session will be available soon on our YouTube channel, so feel free to revisit or share it with friends. Also, don't forget to follow the Legal Forum on LinkedIn and Instagram so you stay updated about our upcoming events and opportunities. Thank you all for joining. Enjoy the rest of your day and keep learning. See you next time. Thank you, everyone, and have a good day ahead.